And now, Legal Perspective with Nick Clekis.
A big settlement might seem like the silver lining after a lawsuit, but when the recipient is a child, the rules change. Here to break down the reality of minor settlements is Nick Clekis, owner of Clekis Law Firm. Nick, great to see you as always. Let's start off. How do minor settlements differ from typical lawsuit settlements?
Well, if you're not incapacitated and you settle your case, we just give you the money and you do what you want with it. But obviously, somebody that's incapacitated or is a minor, we don't just give the money to the parent and let them go buy a pink Cadillac and the child doesn't ever see the money.
And so as an adult, would it typically the lawsuit be paid as a lump sum? Would it be in intervals?
Well, you can structure settlements as an adult as well, but normally everybody wants a lump sum, kind of like the lottery.
Yes, but now obviously we can't do that for a child. So what restrictions are in place to protect that money? They don't get to touch it until they're 18, correct?
Yeah, so we petition the court usually to have the natural parent and guardian or natural guardian as the parent appointed as guardian ad litem, guardian for the litigation. And so then at that point, the judge has to make a decision as to what's going to happen with the money. If the child is getting less than $2,500, we can just give the money to the parent and there's no court involvement. But between $2,500 and $15,000, we have to get it approved by the court with the guardian present.
Okay. And in a perfect world, parents would, do as the court says and make sure that they don't touch that money. But in situations, that hasn't been the case. So what restrictions are in place to protect that money for the child's future?
Well, between $2,500 and $15,000, the guardian gets the money with the restriction that they are to use it just for the child and not to spend it except for extraordinary educational or medical expenses. If it's over $15,000, they have to be appointed as conservator, which is a higher standard of care. The money has to go into a restricted account and they have to report to the court anytime they want to make withdrawals.
And if it's a very young child, let's say, 2 and younger, does that change things if it's a large amount of money at that young age?
At any age, if you want to structure a settlement, you can do that by putting it into an annuity and then it pays out over time. So that if, let's say, you have a $100,000 settlement like I did for a dog bite kid bit in the face, he was 7 years old, we put it into an annuity that didn't mature until he was 18 and it paid out in increments at 18, 19, 20, 21, and 25. So the principal continued to grow as it sat and he didn't get it all at once to spend it. We call it the college plan.
Okay, and that makes the most sense. I mean, an 18-year-old with $100,000 doesn't seem like, the best case scenario. That seems like it makes the most sense. Nick, I want to ask, any advice for parents that may be navigating this for the first time? What would you tell them to do?
Well, you're not going to be able to do this without a lawyer, and so you really need to call somebody.
Right. Call Clekis, 843-9000000 at Clekis.com. Nick, always a pleasure. Next week, we're going to have you in to talk about ride share.
I know.
I'm excited
Uber
for
and
that
Lyft.
one. Back in 2 minutes.
This has been Legal Perspective with Nick Clekis.